Can a trademark owner object to their trademark goods being resold and altered? Under English law, there's a principle called exhaustion, which essentially means that a trademark owner cannot stop its trademark goods being resold if it has lawfully put those goods on the market, unless it has legitimate reasons. What are legitimate reasons? This is an issue that was recently considered in a High Court case between AGA and UKInnovation. AGA objected to UKInnovation refurbishing its AGAs and converting them into electric fuel AGAs. It argued that it had legitimate reasons to do this. The first argument AGA raised was it objected to the refurbishment of the AGAs. The court had to consider whether this was a legitimate reason. It found it wasn't, on the basis it had to be a new product for there to be a legitimate reason. And this wasn't the case here. AGA then argued that by converting the product, it also had a legitimate reason. The issue AGA faced here was it didn't object to UKInnovations' e-control system being fitted into existing AGAs. AGA also argued that by UKInnovation placing its e-control badge on the AGA, this gave it a legitimate reason to object. The court looked at this and it felt that UKInnovations' badge just indicated that the AGA was fitted with its system. Key to this finding was the fact that its badge was quite far away from the AGA trademark. However, the court did find that there was a legitimate reason for AGA to object on the way that UKInnovations' website and marketing materials were. Effectively, they used their brand names next to AGA's trademarks, and the court felt this indicated that the product might have been refurbished by AGA. Accordingly, it found there was trademark infringement. So what does this mean for trademark owners? What the case indicates that in order for refurbishment to constitute legitimate ground, you probably need to have a new product. In relation to conversion, although the findings were fact-specific, if some form of consent has been provided, so here, consent for the product to be fitted, it's likely to not constitute a legitimate ground. The course also indicates that in relation to co-branding, if the co-brander's trademark is sufficiently far away from the trademark owners, there might not be a legitimate ground. It's probably easiest to find legitimate ground from looking at the marketing materials. Is an impression created that the trademark owner is some way connected to the business that's using its trademark? If so, there probably is going to be a legitimate ground. Finally, one question that the court didn't look at because it found it was a matter of evidence was whether if the refurbishment is using inferior parts, this could constitute legitimate ground for the trademark owner to object.